Afternoon, everyone, and welcome to the third panel of the afternoon, Election Law, Federalism, and Its Limits. My name is Guy Charles. I apologize that I cannot be with you this afternoon as a result of some travel snafus, but we have three great papers and two amazing panelists for this afternoon. Professor Yergain is going to go first with his paper on state executive branches under Moore versus Harper, followed by Professor Graber with his paper on Section 3 of the 14th Amendment from the perspective of Section 2 of the 14th Amendment. After that, I'll have a couple questions for both panelists, and then we will turn it over to the audience. And now, Professor Yergain.
I can minimize. All right. Well, I'll echo the thanks of everyone who's spoken so far today for my appreciation to the University of Wisconsin Law School, to the State Democracy Research Initiative, as well as to the staff of the Wisconsin Law Review for putting this fantastic event together. I want to begin with a hypothetical. Let's go back 2 years to 2022. And let's imagine that we're in the state of Wisconsin, which we are, and the legislature wants to gerrymander the state's congressional districts, an unimaginable proposition. And the legislature knows at the time, Speaker Robin Vos knows that he's not going to get the Democratic governor to sign these maps into law. And he doesn't have a 2/3 majority to override Evers's veto, and maybe he's skeptical that the Wisconsin Supreme Court or a federal court will give him the maps that he wants. So he devises a strategy. He decides to put the state's congressional districts into the state appropriations bill. This is actually totally constitutional in Wisconsin. There are no subject matter restrictions in appropriations bills in Wisconsin. And so he puts the districts in the appropriations bill itself. And his real goal here is targeting the state's third congressional district, which is the one in lime green on the left here. It is a district that narrowly voted for Donald Trump in 2016 and 2020, but at this time is represented by a moderate Democrat who just repeatedly keeps winning, rather to his annoyance. And so what he decides to do is make the district substantially redder. They have only voted for Trump by 5 points in 2020. He decides to have the district to the north take over a lot of the liberal cities that are allowing the third district to vote the way that it is. And so he takes this 5-point Trump district and turns it into a 13-point Trump district. Going to be a really hard time for a Democrat in a Biden midterm to win this district. But Evers decides to do something himself in turn. Because this is an appropriations bill, he gets to veto items that are in the appropriations bill. And the Wisconsin Supreme Court for almost 100 years has interpreted the governor's item veto power to include the ability to strike out letters, numbers, words, sentences. And so what Evers does is he takes this district and turns it into this one. It's still a district that voted for Trump by 7 points. Going to be hard to win that in a midterm, but a lot more doable than 13 points. Now you might ask, how is he able to do this? Just based on the district composition, how could he possibly do that even if he has this magic power? Well, if we look at, for example, how districts are laid out in Wisconsin, you might imagine, for example, that in the third district part of the appropriations bill, it spells out all the counties that are in whole, and then it spells out individual specifics for counties that are split. And so all Evers has to do is that for some of them, and that for others, to make counties whole in one district that were previously split between the two. He is entirely able to do this under the case law that the Wisconsin Supreme Court has handed down for almost 100 years. But Robin Vos, being Robin Vos, is pissed off and sues and tries to get the Wisconsin Supreme Court to say, no, 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 this goes too far. But the court doesn't do that. Here's my question at the end of this. Does that violate Moore v. Harper? I don't know. If you look at the text of what the court actually said in Moore v. Harper, it is only about state courts. There's nothing about executives. There's nothing about local government. There's nothing about that at all in Moore v. Harper. But if we take a step back and we examine the context in which Moore v. Harper was decided, The basic problem in Moore v. Harper is that when the US Constitution allocates the power to regulate federal elections to the state legislature, that it is a problem for another branch, in Moore v. Harper, the judiciary, but in theory, either branch, to intrude on that power in an excessive way, such that when one branch arrogates to itself the power that is delegated to the state legislature, transcending the ordinary bounds of what that power typically consists of, then we have a problem. Now, the delegation to the state legislature, the court says, is a choice that we are bound to respect. And it lays out this very traditional schoolhouse rock sounding version of separations of systems of separated powers, where the legislature makes the law, the executive enforces the law, and the courts interpret the law. No, 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 you can't have the court making the law, and you can't presumably have the executive making the law. That goes too far. Now, the court in Moore v. Harper recognizes a couple of exceptions to this. It calls back on some of its older cases to say, well, there are some exceptions. When legislative power is delegated by a state constitution to another entity, for example, in the Ohio Constitution and in many across the country to the people for the power of the initiative and the referendum, that's okay. Or when it's to an independent redistricting commission, as in Arizona and other states throughout the country, that's okay too. So those kinds of explicit delegations of power are totally fine. Now, we might assume then that an implied delegation of legislative power is okay too, but the court didn't really say that. And the cases that it chose, the cases that it has decided, and the cases that it referenced in Moore v. Harper are relatively easy cases if you make that assumption that the legislature can delegate some of its power and that's okay. But we get harder cases that ultimately, the reason that they are hard cases is because the court operates on an incorrect assumption of how state systems of separated powers are organized. Folks working in the state con law space will recognize this, that federal courts do not understand how states are set up. They just don't. And this is especially complicated with executives. And there's two reasons that that is true. The first of them is that in most of the states in the country, executives have a line item veto power. Wisconsin's happens to be unusually expansive, but a lot of executives, indeed all but I think 6 or 7 states, have the ability to veto individual items. But what is an item? Item is remarkably nondescript as a word. And in some states, it is more expansive than others, although Wisconsin still stands alone. So let's imagine a hypothetical. Let's imagine that we have an appropriations bill that allocates $1 million to the state Secretary of State to implement an online voter registration system. Then, as a sentence after that, the appropriations bill says, no use of this fund shall go towards creating an automatic voter registration system. Let's imagine that the governor then vetoes that part that comes after the appropriation itself. Now, in some states, that would go too far. You couldn't do that because the state court might perceive that as a non-item. It is not money, it is not an amount of money, it is a stipulation, you can't do that. But in other courts, there's no problem with that. They might view it as an unrelated proviso that doesn't actually do anything to the choice the legislature made, and it's entirely permissible for the governor to veto that. Well, that poses kind of a challenging situation then, because an automatic voter registration system would apply to federal as well as state elections if, let's say, that actually ended up happening. If the Secretary of State, using their rulemaking authority, did that, that could pose a problem under Moore v. Harper. Because what the governor is effectively doing when exercising an item veto power is they are exercising legislative power. Indeed, the Washington Supreme Court said that in the context of an item veto, the governor effectively holds 1/3 of the legislative power. I think that's largely true if you assume a 2/3 override requirement. But in any event, the governor has the ability to effectively rewrite pieces of legislation. Totally permissible for state constitutions to set up their systems of government that way. This is in their constitutions. But at the federal level, the Supreme Court has said that you can't do that. It struck down a line item veto power when Congress attempted to give the president that power. So what do we do in a situation like that, where we have a situation where the governor is exercising the item veto power in a way that exercises legislative power and ends up regulating federal elections in a way that the legislature did not actually intend? Not a lot of easy answers for this at the end of the day. We might also then think about another way in which state systems of government are radically different at the state level compared to the feds. And that is with respect to the basic operation, creation, functioning of their executive branches. Though we are told we have a unitary executive at the federal level, that is absolutely unequivocally not true at the states. We have, for example, a plethora of other elected statewide officials that frequently include attorneys general, auditors or comptrollers, treasurers, secretaries of state, commissioners of agriculture, insurance, labor, et cetera, et cetera. And beyond that, we also have constitutionally established entities that may not be elected, but are otherwise created in state constitutions. And beyond that, there are some states that don't create a whole lot of entities, but do create an administrative structure. They require, for example, that all executive branch agencies, departments, boards, bureaus, commissions be allocated into not more than 20 departments. All of this is to say that the states have created a system that the feds have not, one that acknowledges the existence of the administrative state. Somewhere near Neil Gorsuch is horrified, right? So what do we do with this? These officials are delegated some amount of power. A lot of state constitutions, for example, designate somebody to administer elections. It might be the Secretary of State, it might be a state board of elections, but they create an entity that is empowered to actually do that. So what happens then when that entity, acting pursuant to a constitutional delegation of power, issues a rule that regulates federal elections in some way? And this is not a hypothetical. In pretty much every single state in the country, minimum qualifications for voters, for example, are established by the Constitution, further codified by statute, and then layered on top of that with administrative rules and procedures. The process by which candidates file for office can be regulated, but is not always by state constitutions, further codified by statutes, and then further by administrative rules promulgated by the state election official. So what do we do with that? How does that fit into the system of that Moore v. Harper articulates, where we have a problem when one branch intrudes too far on the powers of another? This is not something that is a hypothetical concern. This is something that in 2 occasions relating to the 2020 election has been flagged. In one of the many, many cases that the Supreme Court decided after the 2020 election, Justice Gorsuch noted in one of his concurring opinions in a case that it was questionable as to whether the North Carolina State Board of Elections had properly been delegated the power to issue one of its rules. In which case, we're now potentially having the United States Supreme Court step in and contemplate a non-delegation doctrine in the states without any apparent regard for what the state constitution says. Problematic. When Harris County, Texas, for example, implemented drive-through voting, the case was litigated. By the time it got to the Fifth Circuit, it was moot. But in dissent, one judge on the Fifth Circuit noted that it was questionable as to whether the county had actually been delegated authority to do that. So these are not abstract concerns. These are concerns that are quite live, quite relevant, and could very well present problems under Moore v. Harper. The ultimate problem of all of this is that state systems of power blend the executive, legislative, and judicial powers differently than the federal government does. Though there is, in most state constitutions, an express requirement of separated powers, the provisions in the Constitution lay out a blend that is very different than exists at the federal level. And so if we're trying to import federal assumptions about how power is separated, we're going to have some significant problems because this has always been different from the founding to the present. Now, I would argue that the way that we should really deal with this is by turning back to the situations that are actually contemplated in Moore v. Harper, where, for example, there is a delegation by the Constitution of some form of legislative power. The court should honor that. That makes sense. If it is willing to do that when the Constitution says it expressly, it shouldn't really be that different when the Constitution does so impliedly, because there's no other way to characterize the power. We don't need to get into metaphysical debates about what is legislative power, which are interesting and simultaneously boring questions at the same time. We just have to understand that power can be characterized in multiple different ways. And though the Washington Supreme Court, for example, might expressly label line item veto as a legislative power, it really shouldn't matter how we describe it. What matters is that it is permissible under the Constitution. And it's possible, for example, that if a state court shreds all of its previous precedent, adopts a rule or sanctions the exercise of a power that is extra-constitutional in some way, gives, for example, the governor a line item veto power where it is not granted by the Constitution, then okay. Maybe we have a problem under Moore v. Harper if it relates to the regulation of a federal election. Or if there is an unequivocal basis for concluding that a state agency has not been delegated the power to issue rules or to issue policies in those areas, then okay. But even then, we should still be skeptical. But if we take the court at its word that some delegations are okay, then all of these should not be problems at all. The worry that I have, though, is that that does require a little bit of a stretch from what the court said in Moore. I'll acknowledge that. It also requires the core assumption that Moore applies to executive branch actions. I would be entirely happy if it didn't, if the court came back and said, no, no, this is only about courts. We're not worried about executive branches. I think it's a reasonable assumption that Moore v. Harper applies in that context, even though the court didn't say so expressly. But I'd be happy to have that taken off the plate altogether. All of this really goes to show that one of the core problems in Moore v. Harper is this assumption that it makes that states look like the feds. While we have, for example, the same court celebrating, for example, the ways in which the framers of the Constitution, in their unyielding brilliance, split the atom of federalism or of sovereignty to establish this notion of federalism. They frequently harp on the differences that are in the states, the power of the 10th Amendment, all these things. Then that should actually mean something when it comes to viewing different systems of separated powers. That said, I will concede, I'm not terribly optimistic. Because these things seem somewhat beyond them in many different cases, because the federal courts just simply do not understand state systems of separated powers. But I am unfortunately quite sure that we will see exactly how this plays out later this year. And on that cheerful note, thank you.
Professor Graber.
There is a story told in the circles I travel in about a classroom for immigrants about 100 years ago that was considered multi-ethnic by the standards of 100 years ago. And in teaching immigrants how to write, communicate, the teacher said, well, write an essay about elephants. And the immigrant from the United Kingdom wrote an essay on hunting the elephant. And the immigrant from France wrote an essay on the love life of an elephant. And the immigrant from Italy wrote an essay on cooking the elephant. And the Jewish immigrant wrote an essay on the elephant and the Jewish problem. This is going to be a talk that is going to resemble the elephant and the Jewish problem. I'm going to talk a lot about Section 2 of the 14th Amendment, which on its face is tangential to federal and state elections, in particular state role in federal elections. But what I want to argue is that we have taught everyone to view the 14th Amendment in light of Section 1, that Section 1 establishes the core of the 14th Amendment, indeed the core of the Constitution. And so we interpret state power to disqualify federal officers from election in light of Section 1. The argument today is, turns out the framers of the 14th Amendment, most of them could not have cared very much about Section 1. Their 14th Amendment was entirely devoted to Section 2. That is the core. And once we understand that Section 2 is the core of the 14th Amendment, that the framers actually wrote, the 14th Amendment looks different, and state power to disqualify looks different, and indeed our entire constitutional law course looks different. So of course our standard teaching is Section 1 is the core of the 14th Amendment. It is the core of the Constitution. And the theory of Section 1 is we must put limits on government, upon wicked states in particular, and those limits must be enforced by the Supreme Court. Well, if the point, the Supreme Court said in Anderson versus Trump, of the 14th Amendment is to limit state governments, then they didn't get a new power to disqualify candidates. Clearly, it's a limit on states, not an empowerment. Now, there are a number of problems with this first. Notice it's only the last sentence of Section 1 that limits government. Equal Protection Clause, Due Process, Privilege of Immunity Clause, no state shall. Conceded. But Section 1 has two sentences. The first sentence is the Citizenship Clause. All persons born or naturalized in the United States and subject to the jurisdiction therein are citizens of the United States and the states they reside. That's not a particular limit on state government. If anything, it's a limit on all governments. So we move to Section 3. The court said, well, Section 3 limits states. They cannot have candidates who, having taken an oath of office as an officer of the United States, engage in an insurrection. But in fact, it limits the federal government as well as states. There's no special state language or federal language in Section 3 until we get to Congress can remove by 2/3. The president cannot appoint an insurrectionist who held office to office. A governor can't appoint. You can't have a state judge in violation of Section 3. You can't have a federal judge in violation of Section 3. So there's nothing in Section 3 that would say, aha, this is about limitations on state government enforced by the federal judiciary. And needless to say, there's nothing in Section 4 that limits state government in particular. Now, maybe you might say state governments cannot pay the Confederate debt, but neither can the federal government. And by the way, it's only the federal government that can repudiate the federal debt. The court then says, but look at Section 2. Section 2 is a restriction on state power because it says states, if you disenfranchise a percentage of your males, you lose representatives. But that's not a limit. So consider a game. Pick the game of your choice. And a feature, the only thing out there is a feature of this game is different activities are worth different points. And one day, the rules people say, you know, the action we thought was worth 3 points, we're now going to make it 2 points. Well, now you can see game strategists are less likely to take that action and more likely to take other actions. But that's not a limit. What Section 2 says is you're entitled, say as a state, Wisconsin, I think, to 9 members of Congress. I could be wrong. Don't correct me, leave me in my ignorance. But you're only going to get 5 if you disenfranchise African Americans. Could equally be understood as saying you're entitled to 5 representatives, but if you enfranchise African Americans, you get 9. It's simply, in some sense, here are the consequences of your actions. It is neither a limit on government or an empowerment. Well, what is Section 2? First thing I'm going to argue is that, in fact, as I've said, Section 2 is the core of the 14th Amendment. I would argue the core of the Constitution as understood by Reconstruction Republicans. I'm going to talk a little bit about its structure, the role of courts, and how all this applies to Section 3. First, central. Well, let's start with Section 1 that we all know is so important. I have been surveying thousands of newspapers written when the 14th Amendment was debated. So far, I've been focusing on December 1865, the month in which the 13th Amendment was ratified and the 39th Congress sat, and all the various things that went into the 14th Amendment and a lot of things that did not go into the 14th Amendment were proposed. By my count, there are a total of 0 newspaper articles written by thousands of papers endorsing John Bingham's proposal that eventually became the 14th Amendment. I might be wrong. There was a New York Times piece analyzing Bingham's 3 proposals. It has a sentence that seems to endorse Bingham's Rights Amendment. There's one I can't find in my notes I recall reading. So in an optimistic thing, we have 2 proposals. We have more than 100 editorials saying we have to change the basis of apportionment from population to voters. Why? Why is this so important? Well, most of you know about the 3/5 clause, right? Slaves count as 3/5 of a person. The result was that Southerners got lots of extra votes in the House of Representatives and in the Electoral College, makes a big difference in many votes. Well, now there's no more slavery. African Americans count as full people. And by the way, since they're not going to be allowed to vote in most former Confederate states, the estimation is that Southern states will now get 34 extra votes in the House of Representatives, 34 extra votes in the Electoral College. If they can get as much as a little less than 2/5 of the Northern vote for the Democratic Party, they will control the national government. What does that mean? It means that slavery returns with the proviso that you can't call it slavery. Means the national debt is repudiated. The Confederate debt is paid off, that the South gets everything in Congress it apparently lost at Appomattox. That is why apportionment reform is crucial. You have to do something about those 34 extra votes, otherwise you might not have bothered passing the 13th Amendment. And the newspapers consistently say this. They repeatedly say the most important thing we have to do this session of Congress is apportionment reform. Thaddeus Stevens, the leader of Republicans in the House, a radical Republican, introduces a debate on Reconstruction by saying, item number 1, the apportionment. If we do not apportion, we're going to have copperheads and secessionists running Congress. He spends a good deal of his opening speech. Says there are some other things we have to do, but nothing in comparison. First agenda, apportionment. We get this in newspapers. We get numerous proposals. The Pennsylvania Central Committee says apportionment. Got to repeal the ban on export taxes. Got to take care of the rebel debt, union debt. No mention of Section 1. The influential New York Evening Post, Horace Greeley, another barringer of radical republicanism, says we have to pass civil rights laws, but no need for a constitutional amendment. That's apportionment, the debt, the export tax. In fact, when John Bingham makes his proposal, the Post has a big story. important amendment proposed. It's the export amendment. No mention of what we call the core of the 14th Amendment. Well, what's so important? Newspapers give three reasons. First, they point out that's it's basic fairness. Representatives ought to represent voters. In particular, if you do not allow an adult male to vote, you shouldn't get representatives on the basis of that person. The second thing they say is, well, here's a way apportionment solves a problem. Republicans need Black voting in the South. A lot of places in the North, we won't mention Wisconsin because that would be rude to my hosts, have voted down Black suffrage. But the great virtue of apportionment reform is it turns out there aren't enough African Americans in Wisconsin to make a difference. So if Wisconsin disenfranchises or fails to enfranchise male African Americans, they get the same number of representatives. If South Carolina fails to enfranchise African Americans, they lose 55% of their representation. So the idea is at the end of the day, apportionment is a way of getting Black suffrage indirectly. And all the Republican newspapers in the North are confident of this. Second, imagine we don't get Black suffrage. Okay, there go 34 votes. What happens when the South loses 34 votes? That means the government is permanently controlled by Northern Republicans. In other words, this is a heads, I win, tails, you lose scheme. Republicans control the national government no matter what. If African Americans are franchised, there's a strong Republican vote in the South. If they're not, Northern Republicans control. And here is the very crucial point that constitutional law outside of Victoria Norris has lost sight of. And that is, Republicans say, once we have a fair system in which African Americans vote in their appropriate numbers in the South, that's it. The democratic process works, and whatever the democratic process turns out, that's fair. So let's take the question on everybody's mind, segregated schools. There's a hot debate. What did the framers intend? Did they believe separate but equal was constitutional? Did they believe it was not? The answer was they left that up to African Americans in South Carolina. If African Americans in South Carolina believed segregated schools were unconstitutional, they would have the power to desegregate the schools. If they thought, no, either segregated schools are constitutional, or by the way, in return for segregated schools, you'll give the African American community some other things we want, fine. What was crucial to the Reconstruction Republicans was the way in which policy was made in the states, not the particular policy. This is what Reconstruction means. Think of Reconstruction. Isn't you add rights, you subtract rights. It's you change the structures. So now we see we have a threefold scheme of rights protection. Primary source, reconstructed Southern legislatures. If African Americans are voting, you can trust the South. At an oral argument, Anderson versus Trump, Chief Justice Roberts and Justice Thomas sneered at the lawyer and said, name us one person who was disqualified in 1868. Problem number one is, it turns out, with respect to federal officers, most of the southern states weren't constructed. They didn't have federal officers. Problem number two, when they got reconstructed, many of the initial people they elected were African Americans. Not many African Americans in the South had taken an oath of office before the Civil War and fought on the Confederacy. So the reason why no one was disqualified was nobody elected to office was capable of being disqualified. And if we look, we read our Du Bois, what were these Southern legislatures doing? They were doing lots of good things. You could trust a Southern legislature where African Americans were 50% of the vote. That wasn't the wicked state of our imagination. The wicked state came afterwards, when not enough was done to prevent the violence that befell these Southern state governments. So that's the first line of defense. The second line of defense is, imagine the states fail. Well, if they fail, Northern Republicans will dominate Congress, and they can correct the unjust legislation of the South. Now, notice it's always phrased as, they can correct the unjust legislation. It's never, no, Southern governments can't act. This is strictly for Congress. It is, Congress can decide, they can make general rules, or they can decide this is not going right and cover specific situations. But it's a corrective power. Notice I haven't talked about the Supreme Court at all. I'm being historically accurate. They almost never talk about the Supreme Court, but there are a couple of people who say, oh, and by the way, if Congress fails to act, the courts can correct the unjust legislation. But now notice, and I know I'm running out of time, how this affects Anderson versus Trump. First place, there's absolutely no reason to suspect anything is wrong in Colorado. African Americans are voting. Colorado is not the place we consider to be a bane of voting rights violation. It's a state we can trust. Congress had done nothing to correct Colorado. It was fully capable of doing so, it didn't. And what the Supreme Court in Anderson versus Trump failed to say was there anything unjust? Did Donald Trump get unfair procedure? That's unjust. Was Donald Trump disqualified because, for reasons other than participation in insurrection? That would be unjust. Instead, the court decided that, in fact, the framers were wrong, they were stupid. The framers believed elected officials were the best protection of our rights. The Roberts Court, given its history of protecting fundamental rights, says we're the best. No one better. We're going to decide states can't do this because we can't trust states, particularly when everybody votes. Bad idea. So I urge them, finally, take Reconstruction seriously. When thinking about constitutions, when thinking about the constitutions of a corporation that you will one day write, don't simply ask what the words mean. Ask how it will work. That was the question James Madison asked. Not what words meant, how the Constitution will work. That is the question Thaddeus Stevens, the leader of Republicans in the House, asked. Not what provisions made, how they will work. Supreme Court has stopped asking that question. It is forced to imagine a constitution that is originalist only in the sense that we say an original idea is one that has not been thought of before, and their ideas of the 14th Amendment certainly were not thought of by the persons who framed and ratified the 14th Amendment. Thank you very much.
Great. Two wonderful presentations. I will try to pose a question to each and try to be fairly quick in doing so to leave time for those in the room to ask their questions. So first, I'll start with Quinn. Thank you for an illuminating paper and addressing and bringing to bear the problem and the potential problem, looming problem that state executives pose. For me, the core question raised by your paper is really what is the meaning of Moore versus Harper? I think you make two moves that seem to be crucial to the paper. One is the assumption that there is an assumption in the opinion that the court is assuming that the state system and state constitutions and state separation of powers and processes work the same way as the feds, and that that the opinion is fairly exclusive with respect to interpretation by the state courts. I share the assumption in the latter point. I wouldn't say it's exclusive, but it's obviously very concerned with state court interpretation. But I don't understand the first assumption. As I read Moore versus Harper in any event, the what I get out of it is the court saying that to the extent that state courts, and that I would extend that to state legislatures, are operating within the ordinary operation of state law as delegated by the state constitution or by state law, then there is an essentially safe harbor in their interactions with the elections clause. Right. And so the question for me is whether the executive is operating consistent with state law, or is it operating extraordinarily, and of course to the extent that it infringes on the state legislature's authority. So I read Moore versus Harper as providing a relatively, maybe not totally clear, but certainly perceptible line of understanding what the limits are of state authority, or at least non-legislative authority, and the fact that state courts, or in your case, state executives, can constrain the state legislature as long as it is operating consistent with and the language used by the court is something like in their ordinary authority. So, all right, I'm going to just leave that there. I have more to say, but in the interest of time, I want to leave that there, and just to get a sense from you, your understanding of the limits imposed by Moore. Mark, also wonderful and interesting paper. And I agree with you on the importance of using Section 2 and understanding it better. Certainly, I'm not going to disagree with you on that Section 2 historically was extremely important. But I am puzzled by one thing. I'm puzzled by the fact that you seem to read Section 2 as essentially a limitation on federal power and effectively a grant on state power. And if I were there or had more time, I would read the parts of your paper that leads me to that conclusion. Um, and the question that I have for you, it seems to me that the weakness of the constitutional structure when it comes to elections, especially federal elections, are the states. Just today, we could read on the election law blog the fact that Nebraska Republicans are pushing to change the method of allocation to a winner-take-all method, how they allocate their electoral votes. That the states are the weakness. African Americans weren't disenfranchised, as you well know, simply by, right, sort of like an accident. It was the state. And that first line of defense that you note turns out to be the weak point of the whole edifice. So it makes sense then for us to be concerned, or for the court to be concerned by the states and their ability and willingness to play fast and loose with rules that with voter qualification rules. Right. So I'm not sure how to reconcile both the historical worry, right? The fact that we were worried about South Carolina or Mississippi or the southern states, and the contemporary worry that we're still worried about the states, and the fact that they turn out to be the very weak point in the system. That is, if we were to design this process all over again, right, to be Levinsonian about it, we certainly wouldn't come up with this crazy and antiquated framework. So that part leaves me puzzled, though so much of what you say I share, right, including the worry that the court has abrogated power to itself. So just curious to hear you say more about that particular point. All right, so I will stop here, give you all a chance to respond, and I think somebody else will moderate the Q&A as they are able to see the room. And all I can see are the beautiful back heads of Ned Foley and Nick Stephanopoulos, my wonderful, amazing colleagues. But only the back, they're the back of their heads. And there are a couple other people on the other side, but I'm not sure who you are. So somebody else will moderate the Q&A.
I think so. The core of the question that you asked me is basically, am I right about what the court's saying in terms of how it is conceptualizing state systems of separated powers? And I would like to be wrong. So maybe it's hard to answer a question where I'm saying that I'm right, but I'd also like to be wrong at the same time. I think that what I draw from in Moore, first off, is noting that the use of the word legislature is a deliberate choice, and saying that the court must respect the fact that the founders chose to use the word legislature in particular, because the legislature must have some kind of meaning. This is something that was briefed in some of the amicus briefing, what the meaning of the word legislature is. This is something that folks who have been arguing for some version of the independent state legislature theory, like Michael Morley, have said that there is some way to understand what legislature is in the first place. I don't think that's right. I don't think that there's a definition of legislature that is neither over nor under inclusive if you look at legislatures as existed at the founding. One example of that to some extent is Vermont's Executive Council, which I talk about a little bit in the footnote of my paper. At the time that Vermont joined the Union, it had a unicameral legislature. It also had an executive council that was elected at the same time, but it only had executive power. But when Vermont elected US senators, which is something that the legislature of each state did, the House of Representatives met in joint session with the executive council, and for 50 or 40 years, elected members of the United States Senate. The United States Supreme Court never policed this. It never resulted in any contest in the United States Senate as to qualifications, anything like that. This is also the same group that ratified constitutional amendments. No objection to any of that. And I guess I would say first off, the word legislature has really not had a consistent meaning historically, but the court seems to presuppose that it does. Because if we're saying that we have to respect the choice of designating the legislature as something, we have to kind of know what that means in the first place. And I think to some extent, if the court was only concerned with how courts were operating within the bounds of their own constitutions, then there's a really easy workaround to Moore v. Harper. If a state amended its constitution to give its state Supreme Court legislative power, and to say the legislative power shall be vested in a Senate, a House, and the state Supreme Court, then in theory, we have no problem under Moore v. Harper with the state Supreme Court doing anything. We could also further immunize local government officials, state executive officials by doing the exact same thing. But I'm very skeptical that the court would embrace that in any form. The fact that it's trying to police the boundaries of these things in a way that though they're saying it reflects what the state constitution is saying, really seems to reflect a lot of what the court is assuming about what core powers in these spaces are, is something that I find troubling in that respect. And there's ripple effects and externalities in other parts of the Constitution. The 17th Amendment vacancies clause, for example, is another example where there's an allocation of power between the executive and legislature. So the words here actually have quite a bit of meaning. In the interest of time, because I feel like I could talk about this for quite some time, as Carolyn very well knows, I will leave it there. But it's a very challenging question, and I do hope that I'm wrong.
First, thank you very much for participating even in your state, so to speak, and what state that is, I'm not even entirely sure. There are two answers to your appropriate question. Answer number one is I write primarily as an historian rather than as a contemporary lawyer, so I can tell you this is the scheme Republicans laid out. If you're a particular kind of originalist, this is the scheme that you ought to adopt. End of story. Now, I'm not that particular kind of originalist. I think it's worthwhile to know why the Constitution didn't work. Okay, look at the scheme, and Professor Charles, you've pointed out some of the problems with the scheme. But here is one thing they may have gotten right. Why was the judiciary largely sidelined? The answer is Republicans could not imagine federal courts leading a charge for civil rights. There was nothing in their history that said, in the long run, if Congress fails to do much, or if Congress does much, the court is going to improve civil rights and not be retrogressive. And so now we move to 2024 and we look at the past 15, 20 years. Courts have in fact weakened congressional capacity to supervise voting, that if the second line fails, the third line isn't there, that too often when states have acted to expand the suffrage, what the framers of the 14th Amendment said was crucial to the American order, courts have said, nope, can't do this, too close to an election, some other excuse. But the idea, and in some ways it's a John Hart Ely idea expressed 100 years earlier. They really did believe if you have a fair democratic system, that's the best protection for fundamental rights. The crucial thing is, what's the structure that gets you a fair democratic system? They didn't believe judicial review plays a very big role in that structure. And the Roberts Court seems determined, if in a perverse way, to demonstrate the framing insight.